Ladies and gentlemen, dear colleagues, let me present very shortly the EU view on children's rights. European Union and European legislation predominantly refers to public law because of the fundamental features of the European Union as an economic and political institution. Private law is of marginal interest, and family law as one such legal area and children's rights within its framework have only recently become an area of interest to European institutions. I have the impression that in the scope of this broad interest in the protection of children's rights, there is a penetration of new ideas such as gender ideology, which are anything but compatible with children's rights. The soft law is playing a big role in introducing new, let's say, values of European Union, despite the member states have no unified position on this issue. For the European Union to be able to regulate substantive law, its member states should confer competencies on it, which has not yet happened, and the founding treaties should specify the competence of the Union to govern the situation with an international element. In its legal and legislative actions, the European Union is restricted by three principles: conferral of competences, subsidiarity, and proportionality. Efficient improvement of children's rights in response to problems faced by children in Europe at the general level should imply the following issues: fighting poverty, providing quality education without ideological overtones, fighting violence against children, domestic violence and beyond, protecting children from drug abuse, child prostitution, pornography, trafficking and pedophilia, and complete ban on surrogate motherhood, protection of migrant children. Numbers are admonishing. We speak about 80 million children in the EU that are already or potentially exposed to various forms of violation of their rights. This gives reason to think about how much the European Union is prepared to protect children through its legislative procedures and concrete actions, and to what extent it is authorized to do so. When waging the legal status of children on European soil, one should mention the Council of Europe, as my previous colleague said, primarily concerned with human rights, and children's rights are part of the system of human rights, of course. As all the European Union member states are equal members of the CE, the Council of Europe, this is the Council of Europe's indirect influence on the European Union, as all the documents of the Council of Europe apply to the European Union member states. If the courts of every European organization, meaning Court of Justice of the European Union and European Court of Human Rights, are added to this, it becomes clear that 500 million Europeans move within this legal area. I will skip over some normative labyrinth or regulatory jungle, as some researchers say about the European international private law, governed by the need for full exercise of people's freedom of movement as one of the 4 fundamental freedoms in the European Union. Since international private law conventions can influence substantive law, the additional caution is necessary to avoid overstepping the competences of the European Union and infringing on national family law without authorization. Shortly, I would like to point out some important legal sources dealing with children's rights in Europe. The European Union is a subject of international law, but not yet a party to the Convention on the Rights of the Child, and it is not expected to become one. This is not a problem, according to my opinion, because all its member states are simultaneously parties to the Convention on the Rights of the Child. In relation to the judicial practice on both European courts, Luxembourg and Strasbourg, I found a sort of certain symbolic influence of the CRC principles. Namely, the Court of Justice of the European Union invoked the Convention in one case, giving its crucial importance. Opposite to that, the Court of Human Rights in Strasbourg regularly invokes the CRC when judging on the rights to respect for private and family life when children are at stake. There are several documents of the European Union. There are several documents of the European Union related to children's rights directly or indirectly. You see the Treaty on European Union that has a wide general provision on protection of children's rights. The Treaty on the Functioning of the European Union focuses on various areas of family law and children's rights, including no discrimination on age, judicial cooperation in civil matters, procedural law, etc. Two regulations of crucial importance for children's rights were adopted as measures concerning family law with cross-border implications, Brussels II and Maintenance Regulation, that fulfill the goal of ensuring the compatibility of the rules applicable in the member states concerning conflicts of law and of jurisdiction. The Charter of Fundamental Rights of the European Union is a document designed to protect human rights. It is a declaration of the fundamental principles and rights of citizens of the European Union that present their common values. The Charter gave a significant contribution to children's rights, recognizing them independently and separately from the rights of others, meaning adult persons, European citizens and families in general. The Court of Justice of the European Union invoked the right of the child protected by the Charter in several cases. Several articles of the Charter are important for the legal status of children. Some refer to every individual, including children, of course, whereas others refer strictly to children. Provisions affecting the legal status of children are as follows: those on the rights of children, education, prohibition of discrimination based on age, and prohibition of exploitation of children. Some provisions of the Charter govern the family, implying the rights of children, a right to respect for private and family life, home and communications, and right of the family to enjoy legal, economic and social protection. Some provisions not strictly linked to age and therefore applied to adults and, of course, children, alike are the provisions of human dignity, the right to the integrity of the person, the prohibition of torture and inhuman or degrading treatment, and the prohibition of slavery, forced labor, and trafficking in human beings. Moreover, among rights and freedoms are the right to liberty and security, right to protection of personal data, right to freedom of expression and information, right to freedom to choose an occupation and right to engage in work, right to property, right to asylum, and right to protection in the event of removal, expulsion, and extradition. In addition to these divisions, right to marry and found a family within the framework of family law rights can refer to children in the sense of marriage of minors. In addition to freedoms and rights, the Charter emphasizes the principle of equality and solidarity. For the legal status of children, the provision in Article 32, prohibiting child labor and protecting young people at work, is important, as is the provision in Article 33, protecting the family in legal, economic, and social sense, and maternity, in the sense of prohibition of dismissal, maternity benefits, and maternity leave. Although one should expect that provisions on justice, this is the chapter 6 by name Justice, will be interesting primarily to adults, they also refer to children when they are involved in court proceedings. In my research, I paid attention and analyzed very important points of the Charter: freedom of thought, conscience and religion, right to education, and general provision on some specific children's rights. We can conclude that the binding documents do not significantly encroach upon national substantive family rights, either in terms of their wording and scope or the non-contentious content they protect. Legal and political measures in the European Union with regard to children's rights must primarily be based on the founding treaties, especially the Treaty on the EU and the Treaty on the Functioning of the European Union, due to the limited competencies that the member states agreed upon when founding the European Union. The Charter of Fundamental Rights of the European Union is equally important, as it systematizes the existing principles of the Union's legal order. On the other side, there are enormous European Union non-binding documents related to children's rights. Since there is no binding secondary legislation that would be relevant for substantive family law, and such legislation cannot exist on account of the issues of competencies, it follows that it is up to the member states' willingness to accept or reject non-binding documents related to children's rights. Their number, the lack of overview at this moment, and the interference give the impression of their non-contentious importance, something that the states easily succumb to in the sense of their acceptance without reservation. As that it seems that they don't think, what does it mean? In addition to primary legislation, documents that make up the secondary legislation are significant for children's rights within the European Union. They include regulations, directives, decisions, recommendations, and opinions with a varying level of legal binding or non-mandatory nature. There are important, although sometimes considerably similar, soft law instruments that deal with children's rights in the sense of substantive law. Due to the shortness of time, I will just show you their list. You see the strategy, guarantees, guidelines, resolutions, and so on. At the end, because I came to the end, 2 seconds more. At the end, one may conclude that the European Union's soft law in the area of children's rights primarily compromises multiple actions and non-binding documents that have bureaucratically swollen to confusing proportions. The fact of the matter is that children's problems in Europe are not only various but also specific in relation to the problems of children in underdeveloped or developing countries, and are a characteristic of Western society. The features of, let's call it, European problems are threefold and require legal reaction. we encounter social issues underlying legal issues. This is integration of asylum-seeking children, immigrant children, and so on. Psychological issues that are a follow-up to legal issues. Exempli gratia, children separated from their parents because of family dissolution. And finally, children in the judicial system as an issue. All of these questions require a specific response in the sense of binding document for all the European Union member states. In my view, this means that it would be necessary to prepare a corresponding convention or a treaty, as it is customary in the European political and legal system, which would, via the model of the Convention on the Rights of the Child, elaborate on the rights of children who are most threatened in the European area, based on their needs with a simultaneous binding character and sanctions, of course, for the member states. In my view, this should be the first step towards the better protection of children's rights in Europe. Furthermore, such a document should not have ideological overtones, but should be gender neutral and guided by the child-based interest. Thank you very much.